So we are Isaiah Keys and Emily Young, presenting on Sarbanes-Oxley for Dr. Parson's business law class. As finance and accounting majors, we decided to take a look at the Sarbanes-Oxley Act since it's a relatively new piece of legislation that governs financial reporting. Specifically, we wanted to investigate the application of this law in litigation. The corporate scandals of the early 2000s, such as WorldCom, Tyco, Enron, and Arthur Andersen, led to a lack of investor trust, and Congress felt as though it needed to restore the integrity of the financial market, and it did so through the Sarbanes-Oxley Act of 2002. While Sarbox has a number of regulatory laws, there are three main components of the Act. They include the Public Company Accounting Oversight Board, which is meant to regulate the auditing industry, a focus on setting the tone at the top and holding executives responsible, since they contributed largely to some of the fraudulent activities and helped create a corporate culture that allowed those activities to go on. Furthermore, there are new internal controls that are required, and those are new regulations which attempt to decrease the ease of perpetrating fraud within a company. As with any new law, litigation questioned the application of the legislation, and perhaps the most famous example relating to Sarbox is the Free Enterprise Fund versus the PCAOB, which called into question the constitutionality of the board itself. The Free Enterprise Fund argued that the PCAOB had executive power but was not subject directly to presidential control. Instead, the president appointed SEC officials, which then appointed PCAOB members. This dual level of executive power had not been seen before, nor addressed by the courts, but the Supreme Court ruled it as constitutional. The latest portion of Sarbox to be questioned is Section 18 U.S.C. 1519, also known as the anti-shredding statute. There were other destruction of evidence clauses prior to Sarbox, but the intricacies of the laws made it harder to get a conviction with, and people who were guilty were able to get off on technicalities. After Arthur Andersen shredded thousands of documents related to an SEC investigation of Enron, Congress felt the need to create a broader destruction of evidence clause that was easier to apply. The extent of Section 18 U.S.C. 1519 is what we will discuss more in depth today.
Okay, so we realize that the wording of the law is very broad. In U.S. versus Hunt, the court went with the letter of the law, while with Yates versus the U.S., the court went with the spirit of the law. Hunt was a detective who was making an arrest in the process, and in the process got into an altercation with the subject he was arresting. Hunt actually sparked the incident. However, in his report, he found that the subject was the reason behind their tussle. Hunt falsified his reports, and the court convicted him for violation of Section 18 U.S.C. 1519. The court was able to use a previous court decision, Harry versus Marchant, and in this court decision they said that it does not matter what the intent of the law is, only what the law says. Now, dealing with Yates versus the U.S., Yates was an owner of a commercial fishing boat, and the boat was stopped by a patrolman that was running his usual schedule. The officer realized Yates was harvesting undersized fish. Yates allegedly disposed of these fish, and with the destruction of the fish, which was considered evidence, Yates was responsible for concealing and destroying the undersized fish in order to avoid further federal investigation. Yates was soon found guilty because he was in violation of a statute that makes it a crime to destroy or conceal any tangible objects with the intent to influence government decisions. In this case, the government went with the letter of the law. However, the Supreme Court decided that they couldn't convict Yates under Sarbanes-Oxley. The court believed that the tangible objects was too broad and brought their decision to focus around financial information, abiding by the original intent of the law, thus going with the spirit of the law.
However, we feel that the court should have gone with the letter of the law.
In dealing with the section that says any tangible objects, it clearly states any tangible objects and not like other things such as financial information.
Furthermore, with Harry versus Marchant, it backs up the fact that the court should have gone with the letter of the law, because that court case said that the intent of the law did not matter. It was only what the wording said, as long as the wording was clear. And going back to any tangible object, that is very clear wording that does not necessarily just apply to financial matters.
And when we decided letter of the law, because we want to think about simplicity, when dealing with spirit of the law, you have to think of the many factors that play a part, and it can make things much longer and prolong things.
Also, with previous destruction of evidence clauses, as we mentioned before, it was very easy for a party who had destroyed evidence to not get a conviction because of a technicality. Sarbox was more of a broad statute, in which case it was much easier to prove that someone did destroy evidence. So overall, the Sarbanes-Oxley Act was created because of those financial corporate scandals that led to a lack of investor trust. However, the law has come into question before, with the Free Enterprise Fund questioning the constitutionality of the PCAOB. However, the Supreme Court ruled that the PCAOB was constitutional. Most recently, though, in fact, Yates versus the United States occurred in 2015. Section 18 USC 1519 has come into question. Before this year, it was taken as letter of the law, where any tangible object meant any tangible object. However, after Yates versus the U.S., the Supreme Court decided to go with spirit of the law, instead changing it to any tangible object relating to financial matters in the corporate world. We feel that the court should have gone with letter of the law, but it was a very close court decision. It was 5-4, and that just shows that this is an issue that will most likely be coming up again.